The Assisted Dying Bill is a radical proposal that, if passed, would completely redefine how the state sees life and the approach to the end of life in England and Wales. For the first time, if the bill becomes law, the state would sanction terminally ill adults to seek assistance in ending their lives. Currently, if anyone assists another in ending their life, they would face the serious offence of murder. But how would assisted dying work in practice, according to the bill? And why has it sparked such intense debate between the supporters and opponents of assisted dying bill? Let me start with the basics of the bill. The recent formulation of the Assisted Dying Bill sets out a 4-stage process for a person to pursue assisted dying. Under the bill, only adults aged 18 or older who are terminally ill with a life expectancy of 6 months or less and who are mentally competent can apply. They must also demonstrate a clear, settled intent to end their life, clause 1 and 2. The first stage is where this person makes an initial request for assisted dying made in what is known as the first declaration, signed and witnessed by the coordinating doctor and an independent person. The coordinating doctor then assesses the patient's eligibility, confirming the patient's terminal diagnosis, mental competency, and ensuring they are making a voluntary and informed decision, clause 7. The person's declaration must also be reviewed by a second doctor known as the independent doctor, who reviews the same information, verifying terminal diagnosis and the patient's understanding and intent, clause 8. The bill specifies that the second independent doctor's assessment should take place 7 days after the first coordinating doctor's assessment. This time gap is known as the first period of reflection, argued as a safeguard designed, its supporters say, to give some time for the person to consider whether they wish to continue or whether they have changed their mind with regards to assisted dying. The second stage starts once the person has made the first declaration and both doctors have prepared their assessments. The person then applies to the High Court for approval, a form of state-sanctioned assisted dying. The court's role is to review all aspects of the request, ensuring compliance with legal requirements and verifying the patient's decision is both voluntary and fully informed. The court will then issue an official order or declaration if it is satisfied that all criteria have been met. The court-approved step is said adds an extra layer of oversight, giving the court the responsibility to verify that both medical and legal safeguards are in place. The third stage is next. Following the court hearing, the person who wishes assisted dying then must make a second declaration of intent, signed and witnessed by the coordinating doctor and the independent witness. There must be a period of at least 14 days, the second period of reflection, between the court declaration and the person making the second declaration. Or if the person is expected to die within 1 month of the court declaration, a period of at least 48 hours. Once all the procedural and legal steps have been met, the final and fourth stage is the assisted dying. The bill specifies the method of assisted dying must be self-administered. This means that while medical professionals will provide the means known as the approved substance, the person must take the final action themselves without direct administration by the doctor. And further, to prevent abuse, supporters point to provisions in the bill of strict protections against coercion. Any person found to be unduly influencing or coercing a person into seeking assisted dying would face criminal prosecution. This safeguard aims, it is said, to ensure that every person's decision is fully voluntary and free from outside pressure. Now the bill goes into other details, but in short, supporters of the bill argue it provides a compassionate option for those facing unbearable suffering at the end of life. Patient rights groups emphasize the importance of personal autonomy, believing that terminally ill individuals should have control over their death if they choose. And some medical professionals and some MPs are in favour of the bill and see assisted dying as a way to alleviate suffering that even the best palliative care cannot relieve. They argue that the person deserves this option in severe, irreversible conditions. And some pro-assisted dying groups argue that the bill does not go far enough and say assisted dying should be allowed for people with incurable but not necessarily terminal illnesses. These pro-assisted dying groups believe this would extend choice to others with severe lifelong suffering. But opponents of the assisted dying bill and any changes to it, however, voice significant concerns. Many fear that allowing assisted dying could pressure vulnerable people into ending their lives prematurely. Religious groups, some MPs and some healthcare professionals worry that legalizing this practice could create a slippery slope, ultimately devaluing life itself. Opponents of the bill also warn expanding eligibility to those who are not terminally ill, but with a diagnosed incurable illness could lead to further ethical and societal risks as protections and safeguards may weaken over time, such as court oversight or the need for the approval of two doctors. Further, critics of the bill argue that rather than focus on assisted dying, much more needs to be done to support end-of-life palliative care services. And an underfunded palliative care service will only push more terminally ill people to feel like a burden to pursue assisted dying and, ironically, lead to NHS reducing resources for palliative care services. And some medical professionals have raised significant concerns about the requirement for doctors who object to assisted dying on personal or ethical grounds. The bill states that while a doctor is not required to offer or to be involved in the process of assisted dying, if a person requests assisted dying, they must refer the person to another doctor who is willing to proceed. Critics argue that this clause could place pressure on doctors to indirectly participate in a process that significantly conflicts with their personal beliefs. What is agreed is that if passed, the assisted dying bill would mark a historic and radical change in law, offering terminally ill patients in England and Wales a choice never before legally available. That is, state-sanctioned, court-approved assisted dying. This whole area raises profound questions. How should we approach the end of life? Should we as a society, a community, allow people to terminate life? How do we balance individual autonomy with society's responsibility to protect the vulnerable? And how do we cherish and value one another and life itself, however difficult it may have become, if such laws allow for assisted dying? As this debate continues, the assisted dying bill challenges us all to consider how we view life, death, compassion, and dignity in the end-of-life care. Whatever the outcome of the debate, the implications will be lasting and deeply felt. This is why you should join the debate and have your say. Share this video, arrange meetings to raise awareness of the issues involved, listen to each other, and make your individual and collective views known to those in Parliament and beyond. Feel free to comment, subscribe, follow, like, and share.